When does a publicly traded company's duty to share bad news arise? The court deliberated, then revealed the answer in Gallagher versus Abbott Laboratories, whom we'll call Abbott. The Food and Drug Administration, or FDA, had continuously warned Abbott of manufacturing quality control issues within its Diagnostics Division. Finally, on March 17, 1999, the FDA sent a letter to Abbott demanding full regulatory compliance and threatening severe consequences. By September, the FDA demanded changes to Abbott's business practices and a hefty penalty. On November 2nd, the FDA and Abbott agreed to a consent decree requiring Abbott to withdraw 125 diagnostic products from the market and pay a $100 million fine. Abbott filed its annual Securities and Exchange Commission, or SEC, Form 10-K on March 9, 1999, detailing the firm's financial status, but saying nothing about the firm's FDA compliance issues. And Abbott CEO, Miles White, didn't mention the controversy in remarks made at Abbott's annual shareholders meeting in April. But after the close of business on September 29th, Abbott issued a press release describing the FDA dispute, asserting that Abbott was in substantial compliance with federal regulations, and revealing that Abbott and the FDA were negotiating a settlement. Abbott's stock fell about 6% and fell even further on November 2nd, after Abbott announced the settlement. Altogether, Abbott's securities lost over $5 billion in value. Lena Gallagher and other Abbott shareholders sued, alleging that Abbott committed fraud by its silence from its receipt of the FDA's March 17th letter until its September 29th press release. The district court dismissed the complaint, and Gallagher appealed to the Seventh Circuit.